why don't you explain to these folks one more time about the modification of a subject of a noun diminishing its capacity and status withstanding?
All right, so we go back to grade school, and we remember simple sentences like the C-spot run and things like that. And the example that everybody has close to their heart is the phrase, I love you, where you have a subject, a predicate, and a direct object. All right? And because it is a simple subject, a simple predicate, and a simple direct object, there is no temporal or substantial modification, which means that they exist for all time. All right? The phrase, I love you, is a phrase that exists from the beginning of time to the end of time. All right? And the minute you add anything to it to make it sound more special, you make it less special. That's as simple as you can explain it to somebody. So it's like, I love you more than my ex-wife. Okay, great. So now it's conditional. I love you because you make me happy. Well, that means that when you stop making me happy, maybe I don't love you. No matter what you do to that poor, simple little sentence to try to make it sound more cool, you're only going to make it sound worse. And that's what happens in making simple claims in court. If you try to make something sound really important, you're probably making it sound less important. And so one must challenge themselves, especially if you've got a good high school or college education, to write things that sound almost like, C-spot run. And you're going to read your own thing back to yourself, and you're going to go, man, I could do better than that. And you got to stop yourself. You got to say, no, it's actually okay. Because if you just leave it alone in its most simple and perfect form, nobody can dispute it. Nobody can say, well, this didn't really begin at the time of your marriage. This began like 6 months after your marriage. Or this didn't exist at the time of the transgression, or when you ran that stop sign, this was something that you claimed after that or before that, or you don't want to give anybody on the legal side the ability to reach in there and twist your words. And if you make it really stupid simple, it gives you your best opportunity to succeed. Now, I'm not going to guarantee success, but I'm just saying that way you won't shoot yourself in the foot by accident. Okay?
All right, Greg. So thank you, folks, because this is Mr. Greg in Chicago. And if you thought my voice changed, no, that's great because he speaks more eloquently than I do. So what this lady was having a dilemma with, well, ma'am, would you explain to these people who are listening a little bit that when you handed the clerk of the court some paperwork, it sounded very lovely what happened 5 minutes, an hour later when the judge came down. Will you explain to these folks a little bit what happened?
Okay. We submitted our paperwork for the habeas corpus, and within about an hour, the court opened up a court of record to go in with the judge and a stenographer and the court clerk, and basically present our paperwork and explain why we're doing what we're doing. And the judge was very weary of and concerned of our use of the word property in reference to our children. And he was making several references to the movie Lincoln, and how it was inappropriate for us to call our children property, basically referring to them as slaves. And we basically let him know that, well, no, we believe that we created these children from our flesh and blood. They belong to us. They're our property. So we were kind of, caught in a deer in the headlights almost. We were a little mesmerized finally with someone willing to submit our paperwork. Finally, we've been 4 months trying to have paperwork filed and get this thing started and finished. And when he said simply, well, if I could just please change this word property to children, then we could just get this going right now. So we told them that, we really didn't agree with the changes, that we would have to discuss essentially with our counsel. what kind of implications that kind of change would make, and whether we should stick to our word property, so to speak. And he basically insisted, and so we thought, well, if we could just get this in here, maybe we can still kind of work with that. So now we're kind of looking at how do we approach repairing the damages from him changing the word property to children. And we don't know how, whether we should file into this case an affidavit or a letter basically saying, that we still, regardless of the judge's scratch marks on our claim, that, we still believe that these children are our property and that they were wrongfully taken and wrongfully detained, and they belong lawfully with us at our address. It's pretty simple. Now we're just ready to submit an order, and we're not really sure how to proceed with that, how to approach handing it to the judge, going from a motion to an order, and how to present that to the judge at the hearing.
Good. Like I said, I'm glad you guys structured that, and I sent the paperwork over to Greg and help me try to refine it a little bit. But it's simple. What he's doing by making you do a motion is he's trying to still be the one, because like I said to you, what's going to happen on Thursday, you're going to be denied.
Right.
Because you're still letting it and be in his hands, because a motion can be granted or a motion can be denied, just like a wish. Like you say to the genie says, "Almighty Master, what is your wish?" You say, "I'll give you one wish, make a wish." You say, "Well, I wish for 10 million wishes." And you say, "Ha, ha, ha, that wish is not going to be granted. Make another one." See, now the genie has the option. Even as the Almighty Master, somehow you're giving him the capacity to decide what you're going to be granted and what you're going to be denied.
Right. What
you're going to do is you want to basically pull this black-robed one out of any decision process making. Like, look, dude, I'm not giving you a choice. This is an order. And how you're going to stylize it is, the saying is, all you're basically trying to say to these people, when you're doing a writ of habeas corpus, but we agree, maybe we didn't agree. I said you make an order for the return of property. And you say, compare that with writ of habeas corpus, see Exhibit A, and then use whatever writ of habeas corpus forms or paperwork they do up in Canada and attach it as an exhibit. And fill it out lovely. Fill it out exactly like, I'm a Canadian citizen, I'm a subject of the Queen, all this nonsense, because it's just an exhibit. It has nothing to do with your claim. So you say to the man, it's like, look, I know how you like it structured. I know how you folks would like it. But that has nothing to do with my claim. So all you're saying to your claim is that you want, say, I order the return of my property to the proper place of origin under its exclusive jurisdiction. Wow, I said it. When you hear the end of the show, recall what I just said. Make sure your paperwork says that, because you understand what I just said to you by saying I want my property returned to its source or place of origin.
Hey.
You're the source of its origin. You're the place of its origin, the mom. That's where that property came from. That's where that child came from. So you see what I'm saying? Yeah. Nice, simple order. Like when the judge says, like Mr. Gordon Hall says, I order you 15 to 20 in the federal penitentiary. Next case. See how simple that judge's order was? One sentence done?
Yes.
That's all you're doing.
Yeah.
And this is what I'm saying. You order, whoever, you say to whomever is in possession, naked. You can say naked possession. That's a pretty good one. You put naked in brackets if you want. That's fine. Whoever in possession, because naked just means you believe they have no right to hold that. But naked is kind of more legalese word. So you can just say possession. Say to whomever or to whatever, whomever has possession of my property, said property to be returned. You can use the word post haste, like immediately, to its place of origin. Under its exclusive jurisdiction, which means just nobody else has a right to control it but you. So try to just stylize your order for like just one little thing that I just said.
Okay.
And it's on the 30-minute mark. So if you download this thing, then your call came in around the 25-minute mark.
Wonderful. Thank you for that. Now, would we be filing this as a separate case or directly into the current case we've got open going on?
No, you have to be the moving party. You have to get your case placed on file in that court And then when you go into open court on Thursday, what you are going to do is then you're going to have your claim pressed upon a record. And you're going to be the only one who's going to press anything that day because the other side's not have vocal cords or the capacity to answer you. So you're going to claim it's going to stand unrebutted. So you're going to basically win. It's going to be a default. Because you know, and I know, and say it a million times, if somebody from the other side is going to come forth and make a counterclaim, you just do a simple statement like, are you an attorney? Yes, I am. Well, are you saying that you want this property to be in your possession? Are you claiming that you have a rightful claim to this property? Well, no, the Providence of New Brunswick's Family Service Department will let them come to court and press their claim upon the record. And he'll know that press their claim upon the record means they have to speak. It's like, well, I speak for them. No. You can't speak for some man and saying that he wants to adopt a baby. If he wants to adopt a baby, he better come to court and he better say, he wants a baby. Not just dump a baby on some strange man's doorstep. It's like, well, the attorney said that you wanted it. I never said I wanted a baby. What? Your attorney said you wanted one. He can't speak for me. Well, if he's got the power of attorney, not when it comes to something like this. No. I don't want this. So you just demand that it's common law, and a common law practice is that somebody's going to make a claim against your claim or make a superior claim or make say that they have a vested interest like 50-50 with your property. They have to come forth and say it. They can't move an attorney to do it. They're going to have to come forth and speak or forever hold their peace. So I hope that helps a little bit.
Definitely, that'll help us get our claims on the record as well. So, and then we're pretty confident there's not going to be anybody else coming in trying to claim otherwise. So,
okay, there's a man I know on this call. His name is Hale, and he's a sharp kid out from California. And I don't know if he's got any opinions on this, but I see him on a call. So if you'd like to put his 2 cents in, Mr. Hailstone, you're on there if you'd like to say something.
No, I don't really have 2 cents. I'm just kind of interested in trying to get this down a little better. I have kind of been trying to study this common law side and, learning from Bill Thornton and whatnot. So I'm just here to listen and learn.
All right, now I've just been impressed. Listen, you press the issues all the time. So I really appreciate that you always like, volley and I foil and, we duel back and forth, and you hold your own really well, so I appreciate that. So I was just wondering if you had a comment with you.
Well, not with what's going on with this lady. I find what you're doing is very interesting, but with Mel and her traffic ticket, we have a local kid here who's been using, I believe it's 1985 of the California Civil Code on rescinding tickets. She might want to look into that. He simply writes that on a 45-degree angle and uses the same rescission sections from UCC and simply returns it to the clerk of court.
Yeah, but what did you say? Wouldn't your friend believe that the UCC is private law, and wouldn't it be kind of dangerous to practice private law if you don't have permission and you'd be infringing on copyright or trademark standards?
Well, I think I understand what you're saying, but I believe in the context of the way he's using it is they're the ones that are making the offer. And so with their offer, he's using their codes and handing it right back to them.
Well, what I would suggest to him, if this is just something you could throw from me to him, say, this is my belief in how I'm settling off the debt. Not only is this my belief that this is how it's setting off the debt, but I believe it's something comparable to be found in the UCC section, 3 or section 9 was he using? Which one?
Well, see, that's not what he's doing. What he's doing is he's saying that this offer was made under threat and duress, and he's simply returning it because he's not accepting it.
So he's saying it was a dishonorable presentment of him?
Well, not necessarily dishonorable. He's just saying that he's not accepting it. He's not accepting the offer because it was made under threat and duress.
Okay, so he's
for a traffic ticket.
Yeah, so it's basically 3503 he's using. But I'm just saying, whatever he's using, that's fine. That's lovely. Whatever he's relying upon to establish his education, like you are doing, that's great. But don't ever encapsulate their exact codes, because the next thing you know, you go to court the next day and they change them all on you. You got egg on your face because you never know when they're revising the codes. So you use it as an exhibit to attach it to your beliefs, your claim, and then that way, if you get egg on your face because they did it to me one time. It was hysterical what they did to me. They were laughing. How would they think it was funny? But now I think it's hysterical what they did to me. They changed the codes, and I wrote a beautiful brief. But it had nothing to do with anything I wrote. It's like, oh, you tricky bastard.